This season of Trucksafe Live is presented by LogRock. LogRock builds technology tools to help trucking companies stay compliant with federal and state regulations. LogRock is easier. We connect to multiple systems like your FMCSA account and ELD, so you only have to use one system. LogRock is faster. We automate tedious tasks so you can use your time more effectively. LogRock is smarter. We notify you of issues like expiring or missing documents before they happen, so you can be proactive rather than reactive. Setup is easy, and most of our customers are online shortly after signing up. Request a demo now at logrock.com.
Hey everyone, welcome to episode 16 of Trucksafe Live, the monthly show where we and our guests tackle the hot button issues impacting highway transportation. I'm Brandon, this is Jerad.
Hey everybody.
We are with Trucksafe and Childress Law, both of which are dedicated to helping motor carriers develop and maintain cutting-edge safety programs. So this is it, Jerad. Year-end review. Always look forward to these shows, looking back at what has happened over the past yeyear from a regulatory perspective, and more importantly, what's to come next year.
I feel like this year went by extremely fast. I don't know about you, but it feels like we were just here a handful of months ago doing a recap for last year. So
yeah, and even more surprising given how much stuff has happened over the past year. Last year when we were doing it, we were struggling to find stuff to talk about. Luckily this year, well, I won't say luckily because more regulations isn't always the greatest thing, obviously, but it is what it is. So we've got a lot to talk about today. Before we get to that, if you're here with us live, say hey in the comments. We'd love to know you're here, and certainly as we go along, if you have any thoughts on the topics that we're discussing or any questions or anything like that, throw them in the comments wherever you're watching, and we'll bring them up. Before we get to today's topic, let's talk about some stuff that's going on at Trucksafe. As always, we've got a lot of stuff going on. First up, I just wanted to mention the Trucksafe Compliance Network. If you haven't heard about this, it's our own social media, social network platform that we developed specifically for safety professionals, trucking company owners, safety managers, insurance professionals, those types of folks to gather together and really be resources for one another to ask questions about, whatever's going on with your fleet from a compliance standpoint and get answers. And besides that, we also do a lot of network exclusive content. Trucksafe pushes out a lot of content. We're doing monthly educational webinars. All this is free to join. If you're interested, check it out at trucksafenetwork.com. We'd love to have you in there and participating with us. So again, check that out, trucksafenetwork.com. Our most recent webinar was on the most common violations that fleets tend to incur during roadside inspections. We had a lot of good participation in that webinar, folks interested in that topic. More importantly, what fleets can do to avoid those violations going forward. So check that out if you're interested. Next up, I want to talk about the Trucksafe Compliance Boot Camp. This is an in-person conference that we're kicking off in April of next year, where it's going to be a 2-day conference. The first one's going to be in Indianapolis, our hometown, and we're going to gather together around 25 or so. It's going to be a small group, fairly small group of, again, safety professionals, insurance folks, trucking company owners, safety managers, to really dig into compliance at their respective fleets, and detailed information about various parts of the regulations, and more importantly, best practices, what fleets can do to really improve their safety programs and make it cutting edge. So we're really excited about that. Again, first one's in April, next April. Check it out, trucksafebootcamp.com. We're running a promo now. If you're interested in attending, check out trucksafebootcamp.com and enter the code holiday20. You'll get 20% off your registration for that. We're already starting to fill up. So if you're interested in coming hanging out with us for a couple days in Indianapolis, talking all about fleet safety and compliance. I'm sure there'll be some adventures along the way.
Indeed.
Some non-compliance.
Yeah,
things.
looking forward to that boot camp. That's going to be exciting. It's going to be, like Brandon said, very small. It'll be a great chance to talk about specifics of programs and really dig into some of the issues that you're facing, as opposed to just more of a cookie cutter, as many people as you can pack into the conference type of a situation. So I tried to convince Brandon to do it in Las Vegas, but he chose Indianapolis instead. Maybe next year, we'll see.
Hey, we're going to do one in Orlando at the end of the year, I think. If this one does well, then we'll do one in Orlando. Then we can all go to Disney World when we're done.
Perfect. Yeah, that sounds good.
Perfect for those of us with kids, maybe. Not so much everybody else. So anyway, again, if you're interested, check that out, trucksafebootcamp.com. All right, that's it for Trucksafe News here, kicking things off.
Excellent. So as Brandon said in the introduction, today we wanted to do kind of a year-end recap. And again, we did this last year. And in doing the year-end recap, we're going to talk about the FMCSA's activities throughout 2022, but then we're also going to go into 2023 because we actually do have a regulatory agenda this year to talk about, which is fantastic. We have an administrator and an agenda, so we have some things to talk about with 2023 too. So we'll start out with 2022 and get through these key topics from 22 and then move on to 2023. So the first of which is the Safe Driver Apprenticeship Pilot Program. So this was rolled out in January. And we did a show on this and talked about it pretty extensively, but essentially the goal of this program is to alleviate the perceived driver shortage in the industry by allowing those drivers that are 18 to 20 years old to operate in interstate commerce, whereas at this point, most states, if not all, allow these drivers 18 to 20-year-olds to operate in intrastate commerce. So there was a limited amount of registrations in this program. I believe it was 3,000, and my understanding is that it's still open, and there wasn't a lot of traction with the registrations for whatever reason. But what do you make of that, Brandon? That's pretty fascinating.
Yeah, I don't know. I mean, I always heard that maybe some insurance groups were hesitant to insure motor carriers who were using younger drivers. I don't know if there's any truth to that. That's kind of the sense I got. So I don't know if that's driving some of it, or, the other thing probably more likely is just, I haven't seen a whole lot of publication about the pilot program. I don't know if the word got out broadly enough to get people interested in it. So. Yeah,
I will say certain industries like the construction industry, I mean, there are great opportunities to utilize those younger drivers, but I think in an intrastate capacity. And over the years, a lot of those companies and that industry generally has expressed hesitance. Maybe, like you said, it's from an insurance standpoint, or maybe it's from the leadership standpoint.
Well, and the other thing is there's a lot of strings that come along with participating in the program. We hit on this on our earlier show, but participating carriers have a lot of boxes to check when they participate. Number one, they have to apply to participate, and there's kind of a vetting process where the agency goes through and makes sure that it's comfortable with that carrier participating based on its safety scores. But then once they're in the program and they have drivers enrolled, those drivers have to go through kind of a two-part apprenticeship program. It's an apprenticeship program in the true sense, in that during those two parts, the carrier has to be kind of testing them on various topics, safe driving techniques, stuff like that, and evaluating them, and then have somebody riding along with them, an experienced driver riding along with them to make sure. So, I don't know, for carriers who have a lot going on, obviously that's a big ask for them. But certainly if you find yourself in a predicament where you're lacking drivers, maybe this is an option for you.
Yeah, but like you said, some of the hurdles that you have to jump over to comply with the apprenticeship program may have been prohibitive for a lot of carriers. I mean, it's 400 hours, 2 different phases of the apprenticeship program, and at the same time, even some of those larger, more sophisticated carriers, I mean, they're happiest when they're not talking to the DOT.
True.
So that's just a fact.
If you are interested in it, I'll recommend that you go check out the Next Generation in Trucking Association. If you're not familiar with Next Gen Trucking, it's an awesome organization that's all about bringing up the next generation of truck drivers and getting them the education they need to be safe drivers. We've had Lindsay Trent on from Next Gen. She's great to work with. They're doing a lot with this Safe Driver Apprenticeship Pilot Program. So if you're a carrier that's interested in potentially participating, reach out to Lindsay Trent over at Next Gen Trucking, and she can get you the information you'll need. All right, next up, That was the Safe Driver Apprenticeship pilot program. The next big rulemaking that we saw last year was early this year, was the entry-level driver training rule. This was a significant rulemaking, many years in the making. Essentially, it establishes a uniform curriculum for those that are seeking to complete certain CDL transactions. So drivers who are seeking to get a Class A or Class B CDL for the first time, or those that are looking to upgrade a Class B to a Class A, or those who are getting certain endorsements to their CDL, namely hazmat, passenger, and school bus endorsements. Traditionally, they have not had to go through any kind of standardized curriculum in order to be eligible to take the skills test to go get those or to complete those transactions. FMCSA changed that up earlier this year with its entry-level driver training rule. Now those particular drivers, effective February 6th, I think, of this year, have had to go get this. They have to source this training from a registered training provider, a provider that's registered with the FMCSA, get the training, both a theory portion and a behind the wheel portion. They have to progress through that. They have to complete it to the satisfaction of the training provider. And then only then are they eligible to then go take the skills test to get their CDL or complete their CDL transaction. So gone are the days of learning from your brother how to drive a big truck and then going to take the test and being good to go. That's how you learned, right?
Well, yeah.
Okay.
That's how I learned. I mean, it's an improvement without a doubt. It's going to create safer entry-level drivers for sure. The registered training provider list has gotten pretty large. So make sure that you understand if you're going to be looking at one of those training providers, if you're going to be getting an online theory course or you're getting an in-person theory course. Benefits to both, but just understand what you're getting.
Yeah, I think a lot of folks, judging by the comments we get on our YouTube channel, where we've done a lot of videos on our YouTube channel about entry-level driver training, and it gets they get a lot of views from folks who are confused about the rule. And a lot of them don't realize you can get the theory part of the training from an online training provider. I think a lot of folks are under the misimpression that you have to go to a truck driving school in order to complete this to then be eligible to take the skills test. That's not true. There are online training providers. Because the other thing I hear them say is, oh, it's going to cost me $5,000. That may be true if you go to a traditional truck driving school or something like that. But my advice to you is do your due diligence. Go to the FMCSA's training provider registered website and just search for training providers and figure out what they're charging. I know of online training providers that are offering it for a couple $100, the training part. Obviously, the behind the wheel part is more involved and is going to cost more.
And find out what you're getting too. I mean, you can get your hands on an outline of the course, find out generally speaking how long the course is. I mean, if you're just checking the box and you're not going to get anything from this, just the ability to take the CDL exam, I mean, that doesn't seem like it's a great deal on your part if you're going to be paying the same price. But anyways, next 2022 item we wanted to talk about was the elimination of certificates of violation. This occurred in March, and it was the FMCSA eliminating that requirement for drivers to annually submit certificates of violation to carriers. And the agency's reasoning on this was sound. They thought that it was duplicative of requirements to already review annual MVRs. I mean, it seemed like an absolute duplication. So the fact that they're getting rid of this, clear win for the industry, clear win for motor carriers, in my opinion.
Yeah, it was always a pain, although carriers still have to do their own annual reviews of the MVRs, as you said, and traditionally we would see the paper versions that would have the annual review on the top of the paper, then in the bottom half would be the certificate of violations, and so practically carriers would end up doing those at the same time. So maybe it wasn't a huge issue, and if we're talking about paperwork reduction, they were on the same sheet of paper. So
I didn't always see it that way, on the same piece of paper, and then other times I'd see, even if it was on the same piece of paper, sometimes the top would be filled out and the other part wasn't filled out. It's just a paperwork driven violation that motor carriers unnecessarily would get in the context of audits. So that's gone.
Yeah, I agree. It's good. Don't ever say that the FMCSA just enacts new rules and never gives you a break, throws you a bone.
They threw the industry a bone here, but it was a small bone.
True. Okay, next up, big news this year, less regulatory in nature, more litigation focused was the Supreme Court's decision in the AB5 case. So the California Trucking Association versus Bonta case. This was big news earlier this year. We had a couple of shows devoted to it. We had Doug Graw on from the Graw Group, who is much more knowledgeable in this area than either Jerad or I. But the case had to do with the independent contractor status of owner-operators, and whether or not California's AB5 legislation, which essentially is a codification of the ABC test. If anybody's familiar with the various tests that are used throughout the country to determine whether a worker is an independent contractor or an employee, the ABC test is a common test used throughout the country. California's version of the ABC test is unique from others in the country. It's B-prong, ABC, because there's 3 prongs: A prong, B prong, C prong. The B prong in California is very restrictive, and essentially, I don't think there are many that disagree with this, but there may be some, essentially makes it impossible for a trucking company to prevail on an argument that their owner-operators who are leased to them and operating under their DOT number are properly classified as independent contractors under California's restrictive ABC test. So anyway, California Trucking Association sued to enjoin the implementation of AB5, at least in the trucking industry. They actually prevailed at the trial court. Trial court issued a ruling in favor of California Trucking Association and put a stop to the enforcement of AB5 in the trucking industry for many years. And that was, litigated up through the Ninth Circuit Court of Appeals. And the Ninth Circuit Court of Appeals reversed the trial court, and that set the stage for it to go to the Supreme Court of the United States. And the whole basis of that argument was that California's AB5 legislation is preempted by a federal law known as the Federal Aviation
F4A.
Administration Authorization Act, F4A, and which is a law that prohibits states from enacting laws that affect the rates, routes, or services of a motor carrier. In any event, me explaining this in 5 minutes here is not going to do you any justice. So go back and watch our previous show on if you want the nitty gritty about it. Suffice it to say, SCOTUS denies review in that case, which then leads to California now enforcing AB5 in the state against trucking companies. And you saw that in the news, a lot of folks up in arms about it and what it means for their operations and having to potentially change their business model to account for it. And so it's pretty big fallout, at least from what I can tell.
Yeah, the misclassification cat and mouse game in the Ninth Circuit continues, unfortunately. And I don't see where clarity is going to come from. Do you?
No, so that case is not done completely. There are still some arguments. I think California Trucking Association and even OIDA, Owner-Operator Independent Driver Association, they're still fighting in that case, and I think they're making a constitutional argument now to try and get AB5 enjoined again. We'll see if that goes anywhere. I don't have high hopes that it will, but we'll see.
Yeah, that was my understanding of it as well. So moving on from AB5, like I said earlier, we finally have an administrator. The FMCSA confirmed. Senate confirmation occurred, I believe, at the end of September. Robin Hutchinson. So following her confirmation through the Senate, we got a regulatory agenda released, which is fantastic. We're going to talk about 2023 and some of those items on that regulatory agenda later. But again, it's pretty exciting that we have an administrator now for the FMCSA. Hopefully some agenda items can be moved along. One of which that's getting moved along is the end of COVID-19 emergency declaration. We've had these emergency declarations in effect in some form or fashion since March of 2020. Essentially, it's just broad regulatory relief for those that are providing direct assistance to emergency relief efforts. And we've seen the definition of direct assistance and emergency relief efforts. We've seen that stretched to its limits, most definitely.
Yeah, I've worked with a lot of carriers who were operating under that exemption purportedly, and who kind of walking the tightrope. It was right on the edge of what qualifies as emergency relief efforts. The FMCSA didn't do them any favor by issuing such a broad exemption, but regardless, that has now sunset. So as Jerad said, it was in place since March of 2020. FMCSA quietly let it lapse without any fanfare, so it is no longer in effect. So if you're still taking the position that you're operating under the emergency exemption, it no longer exists. So stop that. Which also, this is something we don't even have on our list, but it also, I think, prompted something that just came out recently. We have an article about it on our website. FMCSA issued was it a final rule or was it a proposed rule? I think it was a proposed rule where they're thinking about completely revamping the way that they do emergency declarations to no longer be so broad. So historically, when a governor or president, in the case of COVID-19, issues an emergency declaration, carriers and drivers who are providing emergency assistance or really assistance to the emergency relief efforts, they have historically been exempt from a large swath of the federal motor carrier safety regulations. Everything from driver qualification to hours of service to vehicle maintenance, very broad exemption. We saw with the COVID-19 emergency declaration, FMCSA actually stepped in later in that declaration and narrowed it down to just hours of service relief. So you still had to qualify drivers. Still had to make sure your vehicles were annually inspected, which frankly makes sense. But regardless, the potential revamp they're thinking about is narrowing the scope of those declarations going forward to only encompass hours of service in certain situations. So.
And there was a distinction on when the federal government places an exemption and when a governor places an exemption. So the time distinction, the time allowance that a governor could have an exemption in place, an emergency declaration in place, is limited compared to the federal
government. It was shortened, shortened quite a bit. Obviously, the DOT could extend it if they wanted to, but the default time period for governor-issued emergency declarations is going to be shorter. So I think that will end up going into effect if it hasn't already. Again, I can't remember if it was a proposed rule or a final one. I think it was a proposed one. Okay, and then the last thing that we wanted to talk about that happened this year, this was one of the newer things that occurred, was the FMCSA's guidance that it recently issued on brokerage. So earlier this year, FMCSA had requested comments from the public on whether the agency needed to step in and clarify the definitions that apply to property brokerage and when property broker authority is needed. And that garnered a lot of comments. And then the FMCSA just within the last, it was in November, came out with guidance on this topic where they essentially said they were looking at what constitutes brokerage. How do we define brokerage? Or do we need to change our existing definitions of brokerage? And what constitutes a bona fide agent of a shipper? Because there's this concept in federal law that if you are essentially serving as a bona fide agent of a shipper, then you don't necessarily need brokerage authority to then tender that freight to a motor carrier, because you're acting in the shoes of that shipper, because shippers don't need broker authority to tender their own freight. So what I think the FMCSA was taking aim at are these so-called dispatch services that exist out there that are kind of fitting again in the gray area, I think, in most cases, where they are tendering freight potentially to multiple carriers under the auspices of a dispatch services. So they're not getting broker authority. And so that was the big deal with this regulatory guidance, where FMCSA steps in and essentially, in my view, kind of punts the issue, because what they say is it's a case-by-case analysis. We have to look at all of the facts of the circumstances and figure out, they list out a dozen or so factors that are going to weigh in favor of the entity being considered a broker and that weigh against the entity being a broker. And really, in my mind, it really comes down to, is this entity handling the monetary transactions between the carrier and the shipper? And are they allocating shipments between multiple motor carriers vehicles rather than dedicating those shipments to one motor carrier? Are they potentially handing it off to one or more carriers? And those things, according to the FMCSA's guidance, tend to weigh in favor of the entity being a broker and requiring broker authority.
Ultimately, everyone that had their hopes up that they were going to get clear guidance on this, massive letdown that it's now considered a case-by-case analysis. Yeah. But we did get some factors and a little bit of clarity there, but it wasn't.
It's kind of like the personal conveyance guidance. Just a ton of factors.
Maybe not that bad, but...
Yeah. If you're ever waiting on clear guidance from a federal agency, then you're not going to get it.
Well, we're moving into the 2023 regulatory agenda at this point, and unfortunately, we can't tell you that personal conveyance clarity is on this agenda list. But first is the oral fluid testing. Brandon, you want to jump into that one?
Yeah. So oral fluid testing. This was something we talked about earlier this year, actually, because the FMCSA sought some comments from the public on it. Essentially, what the agency is looking at is potentially moving away from the current system where that only authorizes urinalysis as the only approved method for conducting DOT mandated drug test. Urinalysis right now is the only way you can conduct a DOT mandated test. No hair test, no mouth swabs. It has to be urinalysis, except blood draws in certain very limited circumstances, like when the police do it. But regardless, urinalysis has for decades been the way that we have conducted DOT drug test in this industry, and now the agency is contemplating expanding that to include not only urinalysis, but also mouth swabs to, according to the agency, make things a little easier for motor carriers and collectors to manage. Mouth swabs obviously are less invasive. And more importantly, the problem with urinalysis in a lot of cases is they're not observed. So driver goes and pees in a cup, nobody's watching him. Urine gets substituted in that situation, and now you're dealing with fake urine. Is
it more of a convenience and a less invasive and more difficult to cheat perspective, or is it more oral fluid testing is more accurate? Or are you aware
So I think there's data in the FMCSA's rulemaking on that topic. I don't think that it was necessarily more accurate. I think it may have actually detected the use of certain drugs for longer periods of time, but not all of them. Okay. So there were some trade-offs. But I think the big thing is convenience and making sure, because a mouth swab, those are all going to be observed. It's going to be a person sitting there taking your swab, so they're harder to cheat.
Yep.
So, but again, the way that the notice was structured, it wasn't necessarily saying that mouth swabs are going to replace urinalysis. It was almost like they're going to give carriers the choice of doing urinalysis or mouth swabs. So right now, where it stands, we're just kind of waiting on FMCSA to take the next step, which would probably be a notice of proposed rulemaking, which could come out next year. We don't know for certain, but it could.
Excellent. So next thing on the list, and this is another one that's very contentious, is speed limiters and automatic emergency braking. I think that speed limiters obviously much more of a hot topic and combative topic than what you would find with automatic emergency braking.
Yeah, if we want participation on the show, we can just ask people what they think about speed limiters. Yeah, tell us what you think about speed limiters. Put it in the comments and we'll see.
The perfect speed for a speed limiter is 65 miles per hour. Tell me why I'm wrong. That's part of the problem, is where do you draw the line with the speed limit? I mean, no one is going to dispute that increased speed creates more severe crashes and potentially creates more dangerous driving. However, if you're going to limit a large commercial motor vehicle to any kind of speed, 68 miles per hour, they're going to be on a highway, say in Texas, where the speed limit could be 80 miles per hour. Everyone's going to be going 90 miles per hour. I mean, obviously, you do the math there. That doesn't create a safe environment. That creates a dangerous environment. That's where a lot of people are coming from here.
Yeah, I mean, literally thousands of comments, mostly in opposition from what I could tell. I didn't read every one of them, but a lot of them opposed to the rule for that reason, namely. But essentially where we're at, so FMCSA kind of did this joint rulemaking with NHTSA back in 2016, where they originally proposed requiring new heavy vehicles. So we're talking about trucks over 26,000 pounds, trucks or buses. I think buses, regardless. That was the proposal. They hadn't set a speed, but they were requesting comments on where to set the speed. And then radio silence over the last 6 years on that. And so now in the FMCSA's agenda, regulatory agenda, they noted that they are planning to move ahead with some sort of speed limiter device. I have no idea what kind of form that's going to take, but we will wait and see.
We might have it pretty easy with this one because we might have autonomous vehicles before we have speed limiters, possibly. That was a joke, but it's moving very slowly.
I got it.
It would look like, a regulation that required OEMs to place these speed limiters on newly manufactured vehicles.
It wouldn't be any kind of retrofit.
Right.
Mandate, as far as I could tell. And kind of along these same lines is also another proposal that's probably going to come to fruition next year, which is automatic emergency braking. I don't know much about this rulemaking. I know that it's been proposed for several years now, and I think it would probably take the form of another joint NHTSA and FMCSA rulemaking, where it would be a requirement on newly manufactured heavy trucks going forward. So it's in the regulatory agenda for next year.
Yeah, I think that would be an excellent move. I think that there's going to be a lot less pushback on that one, just because, in my experience and looking at a lot of dash cam footage and looking at a lot of highway accident litigation, it's those rear end crashes that are just extremely nasty, and this would go a very long way to stopping the large majority of those rear end crashes on the highways. Yeah.
Next up, not necessarily on the regulatory agenda, but this comes out of a request that we saw FMCSA publish earlier this year. This is another one where we've got a detailed article on it on our website if you're interested in learning more. But the FMCSA was requesting public input on a potential requirement that commercial motor vehicles be equipped with electronic vehicle identification devices. So we're all familiar with these types of devices now when we talk about like way station bypass devices, where they, a driver installs a transponder type deal in the truck, and then as they pass by a way station, it reads the transponder and gives the way station information to know that that truck is clear to go past the way station without stopping. FMCSA is garnering public input on whether to mandate that type of device in all commercial motor vehicles, not necessarily just to pass way stations, but to transmit data about the operating motor carrier to the way station so that they know that there's a problem or not ahead of time. Things like DOT number, stuff like that, kind of identifying information about that truck that's getting ready to pass by so they know whether to tag that truck for an inspection. So this is another one that got a lot of comments, people not in favor of it, but we'll see if it goes anywhere.
Yeah. Interesting. Another one that is going to garner a lot of commentary is changes to the new entrant audit process. As everyone knows, if you're a new motor carrier, you're going to get a new entrant audit within the first 12 months of you receiving that DOT number operating authority. And the new entrant audit is pretty cursory. I won't say it's something that you don't need to worry about or prepare for, but you can get a couple of bites at the apple with these. You can have a chance to fix the problems that are discovered, and it's mostly just those big red flag issues that you absolutely have to get right to be able to continue an operation well. One of the proposed changes that's kind of in discussion is a potential examination of the motor carrier, meaning someone's going to get a written test. I'm really interested to see where this is going.
This is bringing back bad memories from law school and college.
And we've seen a really big increase in new motor carriers. And I wouldn't say that means that there's just a bunch of new motor carrier operations out there operating. People grabbed up authority and DOT numbers thinking that things were going to potentially change in the future. And nonetheless, if you're going to select someone that has to get a written examination, how do you go about doing that? I'm interested to see just some specifics on what this might look like.
Yeah. This is just in the agenda. There's no details about what they're thinking, but they do mention in the agenda that they're thinking about a mandatory examination requirement for all new entrant motor carriers, which is not completely out there. There are certain permits. I know a lot of states have, if a state has like a hazmat hauler or a hazardous waste hauler permit, some of those states will have a mandatory examination that the responsible individual who's going to be overseeing that program has to take a written exam to demonstrate their knowledge about the topic. So it's not completely unheard of, but doing it in this space is completely unheard of. So actually forcing motor carriers to take an exam, I don't know. Apparently FMCSA is a little concerned with what they're seeing with the new motor carriers that are coming
I will say there could certainly be some quality problems. I'm not going to disagree with that assessment, but I'd love to see some details on how that's going to shake out.
Yeah, we should, if that comes to fruition, we should do a live show where you and I take the test and then grade each other. All right, next up is potential changes to the safety fitness determination process.
Wouldn't be a regulatory agenda without something like this.
No, this one scares me the most out of all of them. Safety fitness determinations are safety ratings. So those watching are probably familiar with the 3-tier system that we have had in place for decades at this point, where motor carriers that have undergone a full compliance review by the FMCSA are scored based on how many violations are discovered, and they end up with either a satisfactory, conditional, or unsatisfactory safety rating. And then those ratings are displayed publicly for all to see, and they have a big impact on customer relationships. A lot of customers don't want to do business with carriers that have anything less than a satisfactory rating. They also have a big influence on your insurance premiums and certainly in highway accident litigation. And so we've been under the same system for, like I said, many years. There's a whole methodology that goes into how the FMCSA scores and assigns these safety ratings. Jerad and I use this scoring methodology when we go in and conduct mock DOT audits for motor carriers. And so the agency occasionally starts to toy with this and decide whether they want to change it up. Last time they did this, I think, was probably back around 2016 or so. Back then, they got to the stage of proposing a rule that would have completely changed up the way we do safety fitness determinations in the country. And they were actually going to tie a motor carrier's safety rating to their CSA scores. So carriers with scores at certain levels based on roadside inspection would get an unfit safety rating, and then they would be shut down. You can imagine that did not go over well with the public or with the U.S. Congress. So U.S. Congress stepped in and told FMCSA, we don't think so. Not until you, FMCSA, address the deficiencies with the CSA program that many in the industry have battled about for years. Well, now Congress told FMCSA to commission a study of the CSA program. FMCSA did that. They got a study. They got a report with recommendations on how to improve CSA. FMCSA, to my knowledge, has been working to fix those issues. And now I feel like they think they're at a point where they can tackle this issue again and potentially propose it again, which makes me really worried if it's going to be anything like that one they originally proposed.
Yeah, we don't really know where this one's going to go, but it is interesting to talk about potential changes to that 3-tier system. I don't really see a problem with a 3-tier system. If you're going to move away from the 3-tier system, potentially having just a thumbs up or a thumbs down, I mean, I'm sure that, folks that are hiring motor carriers and potentially vetting motor carriers based on public information would love that thumbs up or thumbs down. I just don't know how you would go about doing that.
Yeah, I mean, I could see it from the agency's perspective. Right now, the agency is so small relative to the universe of motor carriers that they're charged with regulating that we're in a situation now where they're having to prioritize motor carriers for audit, and they can only go and audit so many carriers per year. So not very many are getting safety ratings. And so there's potentially thousands of carriers out there on the roads who shouldn't be out on the road. And so if we can tie it to a system like CSA that's tracking their compliance on a day-to-day basis through roadside inspections, well, then we can broaden our reach and potentially get more unsafe carriers off the road. But I'm concerned with it's the old CSA issue. Do we trust the data that CSA is pushing out and identifying unsafe motor carriers? Yeah,
I mean, once it can be, even for some good carriers, I mean, if they start getting a handful of violations, ISS score goes up and they start getting a lot more inspections, a lot more violations, and then you could have good carriers that get the thumbs down. I mean, relying strictly on the data, you have to be a lot closer to a perfect solution, and I don't feel like I've seen a perfect solution. I don't understand the new theory that they proposed. I don't think many people do.
It's called the item response theory, and
IRT.
Yeah, last I heard that hasn't gone anywhere. It's been literally like probably more than that, probably 5 years now, where we were under the impression the agency was going to switch to that type of model, and it just hasn't come
Years
to
of
fruition.
work, millions of dollars, and not much to show for it.
Yeah, nothing to show for. Okay, next up.
Clearinghouse changes. So we are quickly approaching the full implementation date of the clearinghouse, which is going to be January 6, 2023. And that's going to be the date in which you no longer have to do the manual previous employer requests regarding those drug and alcohol issues. I mean, obviously, you're still going to have to look at prior employers for accidents and inquire about those accidents and employment verifications. But this will be, again, another one of those steps that, motor carriers can take out of their driver qualification process.
Yeah.
So.
And we've done a couple in-depth webinars on this topic specifically, so check out our website, trucksafe.com, if you want more information. But yeah, that's essentially it. It's, the whole idea with the clearinghouse originally was, this is going to be the central database where all motor carriers who are hiring CDL drivers go to see if their prospective drivers have tested positive or had a drug and alcohol violation in the past, because of the problems that we faced with those manual inquiries where we would reach out to previous employers and just not get a response. The response rate was just abysmal on those.
Yeah, that one. Yeah, that one's always tough too. I know we do a lot of mock audits, and we see a lot of files from a lot of different types of motor carriers, a lot of different industries, and the previous employer checks is always one of those instances where you rarely see a carrier that just nails that and gets that right. So hopefully this takes some of that pressure off.
Yeah. So as of January 6, 2023, if you're hiring CDL drivers, the clearinghouse will be the exclusive means by which you obtain drug and alcohol histories for your prospective drivers. But as Jerad said, the important part is you're still going to have to reach out to the previous employers to ask the non-drug and alcohol questions that you have historically asked, namely verify their employment and were they involved in any accidents that you want to tell us about, that you have to tell us about. So last couple here, potential ELD revisions.
Yeah, ELD revisions. This is one that I'm excited about. So we have a handful of items that are going to be looked at in 2023, requesting comments on potential revisions to the ELD mandate. So specifically around the areas of malfunctions, which has been a really confusing area for the industry. If your device goes into a state of malfunction that prevents the accurate recording of records of duty status, then you can switch to paper logs, and you can do so until the device is replaced or remedied. You have 8 days to do that. However, drivers have no idea typically how to determine whether or not a malfunction is preventing the accurate recording of rods. If they could do some digging, potentially they could figure that out. But they're going to see the malfunction icon on their ELD interface. And a lot of drivers have used that as a chance to switch to paper because they're more comfortable doing that maybe, or they just aren't sure if the accurate recording of rods is occurring and they want to be safe and just switch to paper. Whatever the reason is, there's a lot of confusion around that. So getting some clarity on that issue would be really huge for the industry, in my opinion. And again, that's just been one of those many confusing areas, is malfunctions.
Yeah, I mean, this rulemaking surprised me. I think it surprised a lot in the industry. I didn't really see it coming. So these would be the first big changes to the ELD mandate since it was implemented 5 years ago or something like that.
2017 was the start with the grandfathering period. Then 2019 was everybody was on ELD at that point.
So this came in the form of a request for comments that was filed by FMCSA or published by FMCSA in September, and I expect we'll see some movement on it next year. But so Jerad mentioned the one big thing. Another big component of that is and perhaps the biggest is a potential move away from the self-certification process.
Yeah, the move away from self-certification is an interesting move, and I see the reason for it and the benefit of it. I think we're going to have, some negative commentary from multiple different angles. I think that we've observed the Canadian third-party certification regime go into place, and I think that a lot of the larger ELD vendors are done with that process or still kind of going through that process or wrapping it up, getting that ELD certification through the third party. And they're probably not very excited about jumping into another third party certification. So I think there's going to be some pushback there. But I would say this will probably benefit those larger ELD vendors because they have the resources to go through this third-party certification process. And what it's going to do is get rid of a lot of those devices that are just kind of languishing in the industry. We may have non-compliant devices where motor carriers have tried to save a few bucks and entered into a 3-4 year contract with an ELD that's not very compliant. So this moving away from self-certification is going to vet out a lot of those devices that don't belong in the market, in my opinion.
Well, and this comes on the heels. I think FMCSA revoked its first ever self-certified ELD device this year. I think it was called ELD. It was El Dorado. It was EL Dorado, which I thought was a creative name, but regardless, they're no longer an acceptable ELD.
If you go to the FMCSA's website, you can see the full list of the self-certified devices. You can also see the full list of revoked devices. Now, most of the devices have been self-revoked because of business changes, device changes, updates, things like that. They've self-revoked. There's another provision in these ELD changes that relates to the revocation process. And I think that the theme that you see in this proposed asking for comments on the ELDs, et cetera, you're seeing the agency looking to police ELDs more heavily, and I think that that's been a long time coming, and it's welcomed by the industry.
Yeah. So the last big component of those potential ELD changes, there were a few more, but the big one, the last big one, has to do with the existing exemption that applies to trucks with an engine that is model year 1999 or older. So those trucks are currently exempt completely from the ELD mandate. The idea being that the FMCSA had to draw the line somewhere because they were hearing that certain older model year trucks were not compatible with ELD technology. They weren't able to make that necessary connection with the ECM to be able to report the things that have to be reported. And so they drew the line at 1999 and said anything 1999 or older in terms of the engine is exempt. Well, in this most recent notice from FMCSA, they are toying around apparently with potentially either doing away with that exemption completely or modifying it.
Yeah, that's an interesting one. I think that, how long are drivers going to be able to continue resuscitating a 1999 or older vehicle? I've seen a gentleman driving a commercial motor vehicle with a Caterpillar diesel engine that had millions and millions of miles. It just blew my mind. It was the original engine, and it was older than 99, so I guess in theory it could continue going on like this, but you have to draw the line at some point, right?
Yeah. Well, that component of the notice particularly is garnering a lot of negative comments, so we'll see if that one comes to fruition or not. It's early on in the regulatory stage, so...
Yeah, so if that upsets you, then submit your comment, most definitely.
All right, last but not least, autonomous trucks.
Yeah, interesting. In 2019, we got requests for comments on some of the changes that might be necessary to the FMCSRs, and there's a vast amount of changes that would be necessary to the FMCSRs, but we're supposed to see some activity in 2023 on this front. It's a super fascinating area. It's moving very slowly, but we know that it's coming at some point. One of the interesting things for me, and this probably won't happen in 2023, but we're going to see the new hours of service is going to become maintenance on the vehicles and diagnostics on the vehicles. And are we going to see any kind of movement in the language in the FMCSRs towards that type of approach and others that are necessary?
Yeah. For literally 100 years now, our motor carrier safety regulations that have existed have all contemplated a human driver in the seat. And now, for the first time, we are faced with the reality. These trucks are operating on the highways in various parts of the country. Now we are faced with what do we need to do? What changes do we need to make to these regulations that have grown up with a human driver in the seat to accommodate those types of operations? It's going to be a tall task. Presumably the agency has been working on it for a while now. I haven't seen anything about it, but they were supposed to come out with their proposed rule in November of this year. That has come and passed. So now it's on the regulatory agenda for next year. So we'll see.
Yeah, they can't wait any longer. They really can't, because the states are allowing autonomous vehicle technology manufacturers to operate in certain states. and the federal government's kind of getting left behind because the states are dictating how this can be done. And I've been in fully autonomous 18-wheeler going down the highway, and the technology is absolutely here. So people that say that this is science fiction at this point, it's absolutely not. It is here, and the federal government has to catch up, or the states are going to dictate how this is done.
Yeah, they're booking loads for these things, primarily southwestern states.
In commerce, it's happening.
It's happening. So anyway, all right, that's going to wrap things up for us today. We talked a lot. We had a lot of ground to cover, so we did that. Last thing, I'll just wrap up here with a few more notes about Trucksafe. If you haven't already checked out our online courses, be sure to do so at trucksafeacademy.com. Jerad and I built these courses specifically for safety managers and trucking company owners to kind of go through the nitty-gritty of all of these safety regulations that regulated fleets are expected to know and to comply with. There's a lot that goes into it, so we try to break it down in layman's terms and make it easy for those folks.
And we also have a hazmat course. We also have reasonable suspicion, and we're going to be adding some additional courses as well. So
check those out, trucksafeacademy.com if you're interested. Also, hey, if you're not already subscribed to our newsletter, be sure to do so. You can do that at trucksafe.com/subscribe, and then we're sending out weekly newsletters with all breaking regulatory news and talking about what we've got going on at Trucksafe. So do that, or follow us on our social media pages. We're pretty active on LinkedIn, Facebook, Twitter, all of those. So be sure to do that.
Yeah, and we're developing, our agenda of shows and our topics of shows for 2023. So if you have any items that you'd really like us to touch on, please just send us an email, drop us a comment. We'd love it.
Yeah, do it at trucksafelive.com. That's also where you can learn about future shows and read guest bios, stuff like that. Lastly, just want to say thanks again to the sponsor of this season of Trucksafe Live, which is LogRock. Appreciate you teaming up with us to bring this season to everybody. So thanks again to LogRock. That's it, everybody. Merry Christmas and Happy New Year. We will see you next year.
Happy holidays.